Greetings, inventors, entrepreneurs, business people, authors. This is Michael Folise again, and I'm here to tell you about critical deadlines for intellectual property. In our last video, we talked about patents, trademarks, copyrights, trade secrets, but we really didn't talk about when things are due. And there are deadlines for these important intellectual property rights, and if you don't follow them, you could lose those important rights. With respect to patents, the United States, being a generous country, has a one-year grace period in which you are allowed to attempt to commercialize your invention before you have to file your patent application. Specifically, you have 1 year from any sale, offer for sale, or public use of the invention in the United States, or within 1 year of any description of the inventor in a printed publication anywhere in the world before you have to get your patent application on file. Canada has a similar grace period. Unfortunately, the rest of the world isn't like that. The rest of the world is what we call absolute novelty countries. And in those countries, your invention has to be absolutely novel when it's first filed in those countries. We know from the previous video that novelty means there's nothing identically like your invention. So if you publicly disclose your invention today in the United States, or more importantly, describe it in some way that's enabling, and then you file your patent application in France tomorrow, the French Patent Office will say that your own disclosure is prior art against your French patent application, and since it's the exact same invention, it will lack novelty and not be patentable. So what's the way around this? Well, fortunately, all the countries in the industrialized world got together in Paris, France a long time ago and figured out a way to solve this problem. And they went to something called the Paris Convention, and under that convention, everybody agreed that if today you file a patent application in your home country, and then 12 months later, file it up with a patent application in a foreign country, claiming the benefit of the application in your own country, that foreign country will pretend that the application was filed in the foreign country on the same day you filed the application in your home country. So how does this work? Well, let's say today you file a patent application in the United States, and tomorrow you disclose your invention to the world in a printed publication. And 364 days later, you file a French patent application claiming the benefit of the filing date of the U.S. application. The French Patent Office will now pretend that the application was filed in France 365 days ago, which was 1 day prior to public disclosure. So if you want to preserve your rights all around the world, it means you have to have a patent application on file somewhere before any public disclosure. If you only care about the U.S. and Canada, then you've got a year. Well, is there any way to make this easier? There is. The United States in 1989 passed a law allowing U.S. citizens to file something called a provisional patent application. In other foreign countries, these are often called petty patents or inventor certificates. And they're very similar to a regular U.S. utility patent application, except they don't have to have claims at the end. And the claims is where the patent attorneys earn their money, because that's where specifically the parts of the invention that are new, useful, and unobvious are defined. The first half, which is really just an instruction manual as to how to put the bicycle together on Christmas morning, can be written by anybody who's a pretty good technical writer, along with whatever figures or drawings you need to show how to put the thing together. If you file that provisional application, again, you've got 12 months to file your non-provisional U.S. regular utility application and any foreign applications you want to file. And there are some unified filing procedures for filing applications all the way around the world. So it is possible to preserve your U.S. patent rights and your foreign patent rights without necessarily getting a patent attorney involved by filing one of these provisional patent applications. What about trademarks? Are there any deadlines there? Well, yes and no. As we said in our previous video, trademark rights are acquired merely by selling a product and putting the mark on it. So if I begin to sell women's shoes under the mark Imelda in Washington State, and you begin to sell Imelda's women's shoes in Florida, we each acquire rights market area by market area. And when we get to the Mississippi River, neither one of us can expand into the other one's market area. So the government's giving you an incentive to file a trademark or service mark application with the federal government. If you file your trademark or service mark application today, it's examined, it passes the examination procedure, passes through the publication period for opposition, and the registration certificate issues, courts will backdate your nationwide trademark rights all the way to your filing date. So if I begin to use Imelda's on shoes in Washington State today and file my trademark application today, tomorrow you begin to use Imelda's shoes in Florida, and we meet at the Mississippi, once my registration issues, my nationwide constructive use date is a day before your common law use date in Florida, and I can make you stop using in Florida when I get there. So that's a huge advantage of the trademark registration system. What's another advantage? Well, we now can reserve the right to file and receive a trademark registration certificate in advance. This can be done at the federal level and at the state level. At the federal level, if you file a trademark application today based on your intent to use a mark in the future, the trademark office will go ahead and examine it, tell you whether or not there's any conflicting registrations or application, and if not, give you 3 years after that date to actually begin using your mark in commerce. And then again, when your registration certificate issues because you filed a declaration saying that you're using the mark in commerce, your nationwide use rights get backdated all the way to the filing date more than 3 years ago. And that's a valuable right. What about copyrights? In our previous video, we said a copyright is established the moment you put pen to paper and fix a work of authorship in tangible medium, or take a photo and fix it on film or magnetic media. So what kind of deadline can exist there? Well, here again, the federal government will give you a big advantage if you'll register your copyright. So if I create a work of authorship today and you infringe it tomorrow, and then I file my application for registration, and I have to go to court to make you stop, I have to prove what my damages are. And even if I win the case, I still have to pay my attorney. But suppose you do this. Suppose you publish your copyrightable work today. Tomorrow, infringement starts. But within 3 months of your date of first publication, you file your copyright application. If it gets granted, courts will pretend that that application was actually filed the day before the infringement. And now you're entitled to elect statutory damages, which are somewhere between $750 and $35,000, as the court seems just. And if you win, the other side has to pay your attorney's fees. And that's an enormous incentive for someone to settle a copyright infringement case. And copyrights are very inexpensive to file, only $75. So if you have some copyrightable works and you think they're likely to be copied, then filing an application for registration makes sense. What about trade secrets? Well, there are no real deadlines there. That's the one area where, as long as you make reasonable efforts to keep the secret confidential, then you won't lose the right. So what are reasonable efforts to keep a trade secret confidential? Well, if the trade secret involves manufacturing tolerances for widgets, maybe having a fence around the factory with some barbed wire and having people sign non-disclosure agreements when they come into the factory to visit, would be evidence that you took reasonable efforts to keep the secret confidential. What about software? Well, if you keep the source code in a so-called vault and provide limited access to it, that's reasonable evidence that you made reasonable efforts to keep that trade secret, that is specifically the source code, which generates the object code, a secret, and that'll be protected. So that's really what you need to know about deadlines for intellectual property. But what about due diligence? Do you have any responsibility to find out if you're infringing somebody else's patent or trademark? And what can you do to find out if you could get a trademark or a patent? Is there some due diligence you could do with respect to that activity? Well, if you want to find out the answer to that, you're going to have to tune in for our next video. Until then, live long and, what is it?